That's good. Justice Lewis, perhaps if I can make one brief preliminary remark regarding the issue that arose earlier this morning in argument as to the timing of Mr. Strachan-Ford's death relative to the handing down of the order. It just seemed to me that perhaps Uniform Rule 42.1c may have been relevant in this context, in the sense that the order and the judgment was handed down on the basis of a common mistake, as it were, as to whether Mr. Strachan-Ford was alive or not at the time of the order being handed down.
But that's the order, but not the reasons for the order.
Yes. By the time the reasons were given, it was known by the judge. But it seems to me that the judge should have used Section 42.1, Rule 42.1c to overturn or recall his order on the basis that there was a common mistake which had played a causative role in the determination of his order.
Thank you.
Then, Justice Lewis, if I may, I will just make submissions in relation to one aspect of the matter, which I hope might be of some assistance to the court, and that is concerning the model which Judge Fabricius adopted in determining this matter, in the sense that he applied a judicial supervision model. There are obviously different models that could be employed to determine whether someone should be allowed assisted suicide. In some jurisdictions, one has panels, multidisciplinary panels, which are used. But the procedure adopted by the judge was a judicial supervision model. And I think the judgment of the Constitutional Court in Macmaniani is quite helpful in assessing whether that was an appropriate model in the circumstances. And there are a few passages in the Macmaniani judgment which, obviously in a different context, they're dealing with capital punishment there, but I think they are helpful to this case as well. There's a particularly forthright passage in Justice Sachs's judgment, paragraph 351, where he talks about a circumstance where arbitrariness and the possibility of mistake impacts on the deliberate taking of life. And in his words, that bursts the parameters of constitutionality. And many of the judges expressed a concern about the possibility of error resulting in capital punishment. There's also quite a helpful passage in Justice Chesterton's judgment at paragraph 54, where he sets out in some detail the various circumstances which might result in arbitrariness or error impacting on the decision as to whether someone should be given the capital punishment or not.
How much room for error is there in a case like this? It must be less than where a person is sentenced to death.
I think there still are a number of different areas where error could arise, and perhaps I can turn to that, Justice Lewis. Of course, the situation in this sort of case is exacerbated in that, at least with a capital punishment sentence, there is a possibility of appeal which might overturn a mistake in the earlier decision. But often in these sorts of cases, the possibility of appeal will be illusory, in the sense that the person might by then have exercised their right under the order to have assisted suicide. But leaving aside that factor, it seems to me that if one looks at all the dramatis personae in a case such as this, where you have the applicant, you have doctors, you have psychologists, you have the court itself, and you have the lawyers involved in the matter, and errors could occur at any one of those stages. So, for instance, the applicant might, by mistake or by design, give a wrong indication to the court in papers as to what the motive for his or her decision is. The applicant might exaggerate his or her position, and there might be errors of that kind, not necessarily culpable, but the errors might come in at the applicant stage. Then, if one turns to the doctors, we know that sometimes doctors make mistakes, and sometimes you have a misdiagnosis or an incorrect prognosis as to the probable duration of someone's life. And those kinds of mistakes by doctors could also impact on whether the applicant wishes to have assisted suicide or not. Then one moves to the psychologist, and we see in this case with Ms. Melnick, where it does seem that she perhaps didn't have the full clinical background to Mr. Strachan-Ford's condition. I'm not sure if she knew that at the time he was on morphine, he was on haloperidol, and he was in the condition that we now know from Dr. Cameron's affidavit. We also see that a very brief consultation is arguably not sufficient for a psychologist to form a view as to the person's competence. And one of the experts has said, no, it should be about a 12-week period that a psychologist looks at an applicant before making that kind of recommendation. So one sees also at the level of psychologists, and particularly, I think the point's also made by Mr. Swanepoel, that in a country such as this, the state health system probably can't bear potential applicants spending 12 weeks going to see clinical psychologists before a recommendation could be made of this kind. And that's another problem that occurs in this particular country. And then, besides the applicant and the doctors and psychologists, errors could also come in at the level of the legal representatives. An attorney might, through a miscommunication, the instruction might be confused and might draft something in an affidavit which is not picked up. An advocate might not draw something relevant to the attention of the court. These are all errors that sometimes occur, probably not in the majority of cases, but there's a possibility of errors occurring at that level as well. And then one moves to the judge, and judges are also fallible. It's possible that a judge might pick up an error in the papers, and through that might make a mistake. And I think in Lord Sumption's judgment in Nicholson at paragraph 228, he deals with the issue as to whether it's possible to discern the motives that are animating an application of this nature. And he indicates a difficulty in discerning, as a judge, whether someone's desire is spontaneous or whether it's perhaps influenced by other circumstances which the court might not like to give recognition to. So I think he makes the point quite well, I would submit, that judges also will have a difficult job in discerning whether a case is appropriate or not. And at all those levels, errors could creep into the system. And what one's concerned about when one talks about vulnerable applicants is someone who brings an application but doesn't truly meet the requirements laid down by the law, but nonetheless slips between the cracks and is given permission to commit assisted suicide or euthanasia. And it's that category of person that one would be concerned about. And it seems that everyone accepts that you can never do away with the risk entirely. Even the High Court judge in the Canadian decision spoke about the risk being minimized. I don't think anyone suggests that you can do away with that risk altogether. So we must accept then that if we have a system of judicial supervision in relation to assisted suicide, there's always going to be, whether it be 1 or 2 or 6 or 100 people who are going to slip between the cracks, and an order is going to be given allowing them to commit assisted suicide even though they don't meet the requirements laid down by the law. And it's that situation that one would be very concerned about. And it's that kind of situation which has parallels with the Makbanyani judgment, in the sense that that judgment was also concerned about errors in the judicial system. And I think Justice Chaskerson said that the public, the judicial system is always going to have errors in it. So the question then comes, well, if we recognize that whether it be one person or whether it be 100 people might slip between the cracks and get an order that they shouldn't be allowed, is that an acceptable risk to allow other people who are not vulnerable to exercise their full autonomy? And it seems to me that we then get into the question of limitation under Section 36. And crucially there, one of the factors is the importance of the limitation. And my submission would be that when you're looking at the importance of the limitation in this context, the Judge Fabricius type model of judicial supervision, once you recognize that some people might be given an order or allowed an order which could wrongly allow them to be killed, the importance of the limitation becomes a matter of life and death. One cannot think of a more important...
Paragraphs 3 and 4 stand. Where do we get any requirement for judicial supervision at all? I mean, I can understand possibly something like extravaganza mathematization, but that's not a requirement. It simply says the word murder, culpable homicide is unconstitutional in the context of assisted suicide by medical practitioners.
Just once, I'll have a look at the terms of the order, but I do recall distinctly that in the reasons for the order, Justice Fabricius contemplated that there would be further cases which would be decided, as he put it, on a case-by-case basis. So he, certainly from the reasons, he contemplated that further applications could be made under his judicial supervision model. and he said that the judges hearing those applications will then have to determine on a case-by-case basis whether the relevant safeguards were in place or not. And my concern is that if we leave it to the judicial system to determine whether someone is genuinely desiring of assisted suicide, we have a concern that some people might slip between the cracks and obtain orders which they shouldn't obtain. And it seems to me that if we contemplate that possibility, that someone might be wrongly given assisted suicide, then that's a sufficient reason to limit the autonomy of other people who are not in that vulnerable position.
Mr. Cook, the primary argument in your piece was the separation of powers, as I understood it. And you said that the High Court failed to take proper account of the separation of powers doctrine. It's where you started, it's where you finished. Can you help me? What is, in your submission, the relationship between an infringement of a protected right under the Bill of Rights and the doctrine of the separation of powers, which vests in the courts the jurisdiction and the power to determine whether there has been an infringement of the Bill of Rights? I'm just not sure where the separation of powers comes into that exercise. Either there is an infringement or there isn't an infringement, and separation of powers says that's for the court to decide. So where does this all seems to relate to, well, it would be very nice if Parliament enacted something with all sorts of protections and criteria and so on. Well, it hasn't. So where does the separation of powers come into it?
It's just, I think in a case like this, given the evidence that was before the court, and the evidence which is before this court, that this is not an appropriate case for a court to make a decision of that nature, to make a declaration that the common law is either valid or invalid. But it might be that there are cases that arise where, as in some other jurisdictions, there's cross-examination of witnesses in the High Court, a full record, and the matter isn't rushed through the urgent motion court, as it were. It might be in those sorts of situations that the court would be, as in Carter, entitled to say, yes, this is this law is invalid. And in that situation, I would have said to give respect to the separation of powers, the appropriate order would be to suspend the declaration of invalidity for a period of time to allow Parliament to consider an appropriate law which would be in line with the finding of the court.
All you could do, you see, what the court could do would be what Chief Justice McEachin did in the court below in Rodriguez, where he then proceeded to stipulate a large number of conditions which would have entitled Ms. Rodriguez to physician-assisted suicide. And as I recall it, Chief Justice Vermeer agreed with those by and large.
Yes,
you could do something like that.
The courts in this jurisdiction and elsewhere talk about a dialogue between the judiciary and Parliament, and this would be an appropriate area, I would have thought, where one thinks in terms of a dialogue. So one doesn't want to be, as the courts, too prescriptive in terms of the legal regime, but it would be the duty of the court in an appropriate case to say whether the law is constitutionally valid or not.
Once we say that there is a right to physician-assisted suicide, and to the extent that the law precludes that, that's not up for debate with Parliament. Parliament has to accept it.
Yes, and then what about the one left to Parliament and Justice Wallace would be the safeguards that one might introduce to give the maximum protection. The court might take the view that there must be a way that you can provide sufficient safeguards given the various interests at play, and then it will be over to Parliament to design those particular safeguards in the exercise of its powers.
But the primary question is for the court.
Yes, but I'll come back to my original submission, which is that I don't think this case is one in which there's sufficient evidence for an order of invalidity to be made. And it might be that in a further case, when circumstances are different, the position might be different. As the court please. Unless there's any further questions from the bench.
Thank you, Mr. Cook. Centre for Applied Legal Studies, Mr. Mucci.
As the court pleases. With the leave of the court, I propose to deal with only 3 issues. The first is to accept the proposition that Justice Wallace put to one of my learned friends, that I think for the respondent, that in effect the respondent must come home on the right to dignity if the challenge is to succeed. And we accept that proposition. The second issue I want to deal with is the question of limitation, and just to highlight what we submit are key facts that are relevant to the question of limitation and how the court should evaluate whether any infringement has been justified. And then lastly, we'll deal with the question of remedy, which is what has been debated with my learned friends. So we accept that the core right would have to reside in Section 10, which is the right to dignity. We refer to the other rights because of the interrelatedness between dignity and other rights under the Constitution. And here we have highlighted on behalf of CALS Section 12 of the Constitution, the freedom and security of the person. We submit that the more directly relevant right, which would be interrelated to the question of dignity, there would be 12(2)(b, as opposed to the other rights that have been highlighted in our submissions. And that's relevant in this sense that should the court, if there's debate that autonomy resides in Section 10, then we submit that it's clearer in Section 12(2)(b) that there is autonomy over the control of a person's, the integrity of their body. And that is a right under Section 12 we submit resides in the second part of the heading in Section 10. It relates to security of the person as opposed to freedom. And in the Carter judgment, the court, utilizing security of the person and liberty, established that there is an autonomy of the individual to control their life, not only for purposes of propagating life, but also make decisions about their passage through life. And we submit that is a persuasive reasoning that this court can borrow from.
The reasoning in Morgenthaler, which was the abortion case, in order to get to the right to autonomy in the Carter case.
Yes. All we're submitting is that there's scope for the court to look beyond simply dignity if autonomy doesn't reside comfortably in dignity. The other rights interrelated with Section 10, which would house the right to decide, to make those kinds of decisions. And we the point about the interrelatedness of rights, especially the Section 12 rights and dignity, one finds in paragraph 10 of Makwanyane, where the court discussed that, the relationship between the rights, in order to give content to what the right is in Section 12(1)(e), relating to inhuman and degrading treatment or punishment. So that's the first proposition we deal with. The second is the question of limitation. We would submit that there are certain key elements of the facts that are before the court which are almost common cause or not really capable of serious I'm looking for the words, being controvertible and on a serious basis. And the first is this, is that the purpose of the limitation here must be to protect vulnerable individuals, the vulnerable and the weak, that might not have sufficient exercise, that might not have to be able to exercise sufficient control to avoid abuse of the right to doctor-assisted suicide. And so our submission is, to the extent that the state says the purpose of the limitation is the preservation of life per se, that can be correct. That's too overbroad, cannot be so, because otherwise it would stand in conflict with the law's permission for suicide, even attempted suicide, or the choice by the patient to forego treatment knowing that that is going to accelerate death. So it must be that the purpose of the limitation is narrower than simply to preserve life, because there isn't a duty to live. And as we understand the state, they make that argument on the basis of the Rodriguez judgment, which preceded Carter. But in Carter, the court clarified what Rodriguez was about and said the state was not correct to say that Rodriguez established as a legitimate governmental purpose the preservation of life, that was in passing in the context of construing the content of the right to life, but that the real purpose that was identified there is to protect the vulnerable. And we understand the HPCSA to accept that to be the purpose. Now, if that is the purpose on the one hand, then immediately what arises under Section 36 of the Constitution in respect of limitation is whether the measures adopted of an absolute prohibition, and here I submit cautious of the debate about Croat John between the bench and my learned friends. I'm submitting on the basis that there is an argument, a good argument, that there is still a prohibition against doctor-assisted dying, or they fear that the Health Professions Council would prosecute for ethical contraventions a doctor that delivers doctor-assisted suicide. On that basis, we submit...
Help me with this. The difficulty with the notion that in some cases doctor-assisted suicide might not amount to murder. Either the chain of causation was broken or there wasn't the intent necessary. The difficulty is knowing in anticipation what would constitute murder or culpable homicide or what would not. What sort of action would give rise to prosecution and what would not. How does one deal with that?
We would submit that the court must proceed on the assumption that, correctly, that in some instances it may be unlawful, in other instances not. And because of that, you need certainty, because part of the rule of law is that citizens must know what is or is not permitted by law. And so one needs clarity to say, in the event that it could constitute a prohibition, this is lawful because the Constitution protects it. And that is the clarity that would be required.
Wouldn't you need, really, doesn't that drive us back to the inadequacy of the record in this case, that one would be better off with the kind of record that was built in Carter, where one of the applicants was a doctor who said, this is what I propose to do with this patient, and you could then look at it and say, well, that will or won't fall into forbidden terrain.
Yes, that's correct, Justice Wallace. The unfortunate position, of course, is that the court is faced with an issue that has to be determined on an inadequate record, where the option of referring the matter back to the High Court no longer is live because the applicant is not with us anymore. And so the court has to make do with the difficult situation and try to answer the questions at a principle level. And that's where I submit that it should be answered on the assumption that there will be instances where it could be a criminal offence, culpa or intent or murder.
Is Section 39(2), because if the reading I have suggested to counsel Grotjon is correct, then by a sensitive and appropriate application of Section 39(2), one would arrive at a place of greater certainty.
Yes.
Yes, it is correct. As opposed to trying to build it under section, the justification section.
Yes. No, that is correct. If the court were to want to develop the common law, then one has to be precise about what the common law rule is. On the other hand...
Can we do that?
On the other hand, that's not the only remedy, because the court can...
Can I just go back to that, Mr. Maniaci? Can we craft a careful order in a matter such as this, where we actually don't have facts before us? Would it be appropriate for this court to lay down the principles?
Yes. We accept that deficiency is a problem, but what is quite plain is that from the regulatory framework, which is established by the Health Professions Act, and then the ethical rules, which are regulations, the binding rules, we're discussing in a case before this court in LaRue, the statutory framework, that under that statutory framework, it's quite clear from the regulatory body that they will take disciplinary action against doctors that grant doctor-assisted suicide. So there is an impediment to a citizen accessing that right, exercising that right, because there is a legal framework that stands in the way. So we would submit that even to the extent that the criminal position is unclear or debatable, there is the regulatory framework which is plain, which is clear, and therefore there is a factual basis on which the court can say there is an infringement of the rights, and if the right exists, and ask whether that infringement is justifiable, whether it takes the form of a criminal sanction, the limitation, or takes the form of statutory sanctions under the regulatory framework. I accept that might not be a satisfactory position, but we simply make those submissions as possibilities of looking at. It's an undesirable.
There must be possibilities for the future, must there not?
Yes.
Mr. Maleti, but if there is a difficulty in determining whether or not there is justification, or whether this court can craft a less restrictive means for the infringement of the right, and if the court comes to the conclusion that on the facts that such a process is inappropriate, then does it make any sense for the court to rule as to whether there's an infringement to begin with?
I missed, just to get it clear, Justice Kepas, is it if the court can't give an effective remedy, or if
the court cannot make a determination in relation to justification because it cannot craft a less restrictive alternative, then is there any point in making an order in relation to the infringement in the first place?
We would submit yes, because under Section 172 of the Constitution, perhaps let me backtrack. If the applicant, the respondent, was alive and needed an effective remedy, the Constitutional Court and this court would say if there's a finding of unconstitutionality, there must be a declaration followed with an effective remedy. Then that effective remedy would be to give effect to the right so he can exercise it. But because you don't have a claimant, as it were, who requires an effective remedy, the court could make a declaration which would inform Parliament on steps to pass proper legislation, and that
effectively an advisory opinion.
Well, not quite. Under Section 172.
Well, you've taken us to 172, so let's just look at that if we may, Mr. Maleti.
Under Section 172.
I know what it says. Let me put the question.
Yes.
You know what it says. I know what it says, so let me put the question. When deciding a constitutional matter within its power, a court must declare that any law that is inconsistent with the Constitution is invalid to the extent of its inconsistency. Well, let's just stop. What law are we going to declare is invalid, and to what extent is it inconsistent, until we've solved the conundrum about what the law is in Grotjon and everything else, and indeed whether that law should have in itself have been developed under Section 39(2) of the Constitution.
What I accept, Justice Wallace, that is a problem, because the law must be clear, so that the court can determine the extent of the inconsistency. But that, with respect, is what the court must engage in. So this court is required to inquire whether the common law rule that everybody came to court saying prohibits doctor-assisted suicide is correctly interpreted or not. And if this court were to find that it hasn't been correctly interpreted, because it wouldn't prohibit the type of relief that was sought in this case, as opposed to some other case.
What if we were to say that the judgment has been misunderstood and misinterpreted, and the facts of this case do not provide appropriate circumstances in which to articulate a clear view as to the effect of the reservations Stain CJ put in the judgment? That's in the discretion of the court. Can do that in terms of its discretion on whether this is an appropriate case to decide, and what appropriate remedy to grant. But our first submission to the court is that the court would go through the exercise to determine whether the parties
are correct, that there is a prohibition. If there is a prohibition, that the court would reach the constitutional issue and make a declaration.
We can't determine whether there's a prohibition until we have the appropriate facts. We can't determine whether there's a blanket prohibition, an overbroad prohibition, a limited, justifiable prohibition. None of that is effectively before us. So whatever this court would say would be arbiter, would it not?
Unless the court, and we submit it, could take the view that at the minimum, for the minimum relief, the lowest level relief that Stranson Ford wanted was for his doctor to merely provide the means. And as Justice Wallace took up with Marlene Friend for the first respondent, there is nowhere in the papers where it suggests that what he required was that the doctor should administer the agent. And to inquire whether, accepting that to be the lowest relief that he wanted, which he could have get as an alternative relief, whether that is prohibited by the Hodgson ratio, and if it is, whether there is an inconsistency with the Constitution. But accepting the limitations that the court has raised.
Help me just one other aspect. I'm sorry to pass on John. It's not an easy case to read. What are the circumstances in which Justice Stone thought that someone could be convicted of culpable homicide in the light of what he was saying? But he certainly left that open.
Yes.
Are you able to cast any light on that? If you can't, just leave it.
I think it's the issue whether on the facts you've got that are before the court, one can say, well, even if it is a bright light that this can be a murder, whether it could still be culpable homicide is a question that the court would have to grapple with.
But the tests that go to intention, either to intention or to negligence.
Yes.
Mr. Maneki, before you proceed, can I just ask you one question that's troubling me, and that is this not the Zansi scenario, where the court can make a finding and decide this case on other than coming to the constitutional issue? The court can say there's insufficient facts. The court, without more, below adopted Carter's reasoning without proper consideration, and the facts were more fundamentally for its order turned out to be incorrect, and therefore it is not necessary to decide the constitutional question on the Zansi line of cases.
Yes, that's one possibility. The only difficulty, of course, with the way in which the Cameroon evidence comes up, the clinical evidence come up, is that it comes up late in the day, so the respondent doesn't have an opportunity to show whether that might be correct, misinterpreted, or not misinterpreted. That's all I'm saying. So there may be questions about
any attempt to put those medical records before us. They actually opposed the application, had to come to this court. They were asked them, they could have just given it. They opposed it. This court had to make an order.
And lastly, Mr. Maneki, the reason why I'm looking at the Zansi line is because the order in paragraph 1.4 of the court below authorized the administration of a lethal agent by a doctor.
Yes, well, that is correct. But that would raise the constitutional issue. That order granted, because it might not sit nicely in the Hodgson reasoning that is not a...
That's clearly murder.
Yes, but I didn't understand that the case is argued on the basis that that's what the respondent wanted. So that is...
He asked for it, and it's in the order, although the founding affidavit doesn't.
So that might be a basis on which the court does reach the constitutional issue, because that then raises the question whether it is a right protected and whether there's an infringement, and there might be clear criminal prescription against it. Just bearing in mind the purpose of the limitation, we would submit that the measures that are adopted, which is a complete prohibition, depending on the interpretation of the law, that those measures were not less restrictive. And on this basis, on that point, the evidence before the court is quite, it's uncontroversial that not everyone that requires doctor-assisted dying is vulnerable, firstly. But secondly, that the other jurisdictions show that you can have measures in place to afford the exercise of the right without a blanket prohibition. The efficacy of the measures will always differ from jurisdiction to jurisdiction, and we accept that the court must bear in mind our particular circumstances, because to a large extent it might depend on the medical culture in the particular country, how much consent is informed and is obtained, and things of that kind. But we submit that the existence of measures is not a controversial issue. It is there, and it's one that could ameliorate the extent of the limitation. Just on the particular circumstances of South Africa, may I just say something about lack of resources?
To be satisfied that the measures were effective.
Yes. The court would have to be satisfied that the measures in those countries are reasonably effective. Carter, of course, had the benefit of a trial and could reach that conclusion, and this court doesn't have the benefit of that to deal with the differing accounts of what statistics show in the different countries which are permissive. But there's an indication there that less measures could be applied. Now, on the lack of resources and the nature of the South African society, we just submit that, as the Constitutional Court and perhaps this court always has said, the lack of resources argument is generally easily made by the state, and often the courts require that it be properly justified, because this court doesn't know the extent to which the extent of the burden that would be placed on the state, and the extent of the resources that the state would have to contend with such a burden. And so one wouldn't readily accept that the mere mention of lack of resources is sufficient to warrant a limitation of this kind. And then the nature of the South African society, of course, we accept that we have different socio-economic conditions in our country, but we also accept that there are other pro-choice rights, if I can put it that way, that are derived from personal autonomy that have been recognized, such as the right to abortion, which would similarly place a burden on the health system. But those the country is coping with, absent any indication to the contrary. So those kinds of justifications put up without proper explanation mustn't readily be accepted by the court. And we would submit that in light of the breadth of the prohibition and the limited nature of the purpose of the limitation, the measures adopted are not in line with Section 36 of the Constitution. Then, if I may deal with the question of remedy, I think that is, in a sense, the debate that the court raised with me earlier, and that is our principal submission. If there's an infringement, it's not justifiable, under Section 172, the court has to make that declaration. Of course, it's then open to the court, given that there is no requirement for an immediate effective remedy in the absence of the respondent, that the court might leave it to be the ambit of the right to be developed on a case-by-case basis. Alternatively, may, under Section 172, say this is a matter properly to be dealt with by Parliament. Parliament must legislate for measures. But if the court were to do that, we would submit that a time frame must be given to Parliament because of the experience that it's been on the horizon for so many years, and we know that the submissions about other priorities, and one doesn't know when that would when Parliament would come to the task and fulfill that. But there would have to be some time frame, but it would be an appropriate remedy to declare the rights, declare what the law is, and simply say Parliament must provide a framework in which the right can be properly exercised. Those are our submissions, unless there are further questions.
Thank you very much. Yes.
I want to press an issue that has been raised by the court relevant to Doctors for Life. It's not on the issue that the court has ruled should not be heard. This goes to the procedure that we stand by in detail of the respondent.
Yes, you may then come forward and make your point, but subject to a time limit.
I hope to be no more than 3 minutes.
I'll give you 5.
You would have read in the record that Doctors for Life complained in their opposing affidavit in the court of quo, where they also applied to be joined as a party, about the conduct of Mr. Strantham-Ford and his attorney. One finds that in the record at volume 2, page 242, paragraph 21, to page 247, paragraph 35. If I might just draw attention to what initially occurred, is that the attorneys acting for Doctors for Life, who instruct us at that stage, learnt of the application. They wrote to the attorneys and asked to be informed about the matter and where we could get a copy of the papers. They wrote back to us, and this is in the record, and they said, the applicant's human rights, his life or his death, we have no interest in that, Doctors for Life. So quite clearly, as was correctly pointed out to Mr. Murray earlier on, the approach to the court was not in any public interest. It was clearly a 38A approach. However, this conduct persisted in the proceedings before this court, which yourselves as the justices sitting here may not have had regard to, and that was the application by Doctors for Life to be admitted as amicus, because the President would have made that decision, not any of yourselves. I don't have any, I can't refer you to a paginated set of papers in that regard, but I would like to draw your attention to what did transpire. Doctors for Life's attorneys took the approach that Doctors for Life did not necessarily need the permission of the respondent to be admitted as amicus, because we didn't recognize their locus, for reasons that have already been alluded to. But nonetheless, Causa Abidanti made a request that they give us that consent, wrote to all the other parties, were given that consent. And at page 5 of Doctors for Life's application to be admitted as amicus, from paragraph 5.8 onwards, one reads what transpired. It set out there how the other parties granted their consent. And then we address the consent to the attorneys acting for, or that our learned friends are instructed by, for the supposed respondent. And in asking for consent, we specifically drew attention to the fact that we did not concede that the estate had any interest in the appeal or that it could refuse the consent. In fact, we went further to say that they didn't even have an interest in a costs order. There was no costs order. Now, what then transpired is that the attorney for that instruct our learned friends, we don't really know who they act for, and my submission to you is there's no evidence before you who the attorneys who instruct our learned friends in fact act for. And this, I would submit, is of some relevance in that the attorney acting for or instructing our learned friends filed an affidavit with the President in which she merely said, an opposing affidavit, it's Miss Sally Ann Buitendijk, and she said, I am an adult woman, an attorney of the High Court, and gave the details of the practice in Causey Rogers, proceeded to deal with the knowledge of facts that she has knowledge, that she's perused our application, and the purpose of the affidavit was to assist the President of the Vulnerable Court and highlight the mere fact that the applicant, just because the Doctors for Life had obtained consent from other parties, doesn't mean we should be admitted as amicus, and it's not conclusive of our admission, and that any submissions, there is no reason to conclude that the applicant will make any submission that differs from those of the appellants, and that was 4 pages, including the heading. There was no disclosure of who she acted for, under what authority, as one ordinarily has. Now, we need to draw that to your attention and to press the issue that we submit that they don't have locus standi. We've made this issue from the start. At a point we thought it was a non-issue, but it was raised by the court today, and it's an issue that we had raised in the papers. We persist with it. It may have some implication or some relevance to how one applies the the costs, the cost arguments and tests at the end of the day.
Thank you.
Thank you.
Some cosy Thomas.
Justice Lewis and Justices of the Court. We don't wish to repeat much of what has been said here today, but we wish, however, to emphasize that which we stated in our supplementary heads of argument, which we did not really deal with on our feet this morning, namely the underlying reason for the common law rule proscribing the absolute ban, so-called. We stated in paragraphs 27 and 28 and further of our heads that the underlying reason for that was, first of all, the protection of the vulnerable and weak. We continued at paragraph 28 to quote from the judgment, from the Carter, the Rodriguez judgment, where Justice Sopinka infused into the conversation issues pertaining to the state interest in protecting life, and saying that that is also to give effect to, is consistent, as it were, to the state approach in that matter, in that state, in Canada, to the policy, let me just read it, but also it is in accordance with the policy of giving effect or proscribing, as it were, capital punishment, and until its repeal, attempted suicide. What we submit images there is that in a democracy such as ours, where we value the right to life to the extent that we do, it is not unreasonable of us to have a rule totally prohibiting, as it were, assisted suicide. We refer also, Justices, to other passages from the Mankwanyane judgment where the same theme emerges. And there we refer to paragraph 144 of the said judgment, and that appears at paragraph 30 of our written submissions, where the justice there in his concurrent judgment said that our protection and respect of the right to life, the unqualified right to life, has to be clear, and it has to be shown and demonstrated in everything that we do as a state. He says there, and this must be demonstrated by the state in everything that the state does. And we see that as one works through the jurisprudence in cases such as Thebe, where the court refused to extradite a foreign national because there was a threat that that foreign national, after extradition, they would be exposed to capital punishment. And then the Chief Justice Langer, as he then was, states as follows at paragraph 222 in Mankwanyane. That passage appears on page, is paragraph 32 of our written submissions. And there he says that as government, for good or for worse, we have to be a role model on matters of protection of life and the respect, as it were, of the right to life. And we are simply making these submissions to invite justices of this court, when the justices eventually look at this common law rule, the impugned common law rule, the total ban on assisted suicide by physicians, to infuse into that conversation our fundamental values derived from this, as given expression, I beg your pardon, by this jurisprudence to which we refer. We have been criticized by CALS to say that on our how we formulated the object, the underlying object of the rule, we were overly broad by relying on the protection of the right to life as opposed to the narrow basis, namely the protection of the vulnerable. Nothing in our respectful submission turns on what underlying rule or underlying objective we rely on. But what matters in our respectful submission is that the Carter judgment falls to be distinguished from the facts of this case, because in that matter, a full trial had been run at the court of court, that's the first thing, and based on the evidence, the appeal court was satisfied at paragraph 104 that there was adequate safeguards in place to protect the vulnerable. Justices of the court, there is no such evidence before you. We submit that this court is unable to reach that conclusion based on the material that is before court. Therefore, we submit, justices, in conclusion, that the order that would be appropriate in the circumstances would be one, upholding the appeal and dismissing and substituting the order of the court of court with one dismissing the application. And we are not asking for costs. We submit that the rule in Baywatch applies. Those are submissions.
Thank you. Mr. D'Oliveira, are you doing the reply?
May it please you, Justice. May it please the Court, I intend to be similarly brief. There are just 4 points which I wish to make. The first concerns the ongoing discussion concerning Grootjon and the law in Grootjon. The submission to be made is that there is a further reason why this Court should certainly exercise judicial restraint in entering into the territory of Grootjon and what it may or may not say in its judgment. The reason for that is that if an indication were to be given in a reported judgment of this Court that it may, in certain circumstances, be permissible for a doctor to give a lethal prescription to a patient, and there may be circumstances where there would be a novus actus or a sufficient passage of time which would mean that it wasn't an assisted suicide for the purposes of Grootjon. Then we open up a scenario where there's an indication that doctors might be able to do this, but there is no indication whatsoever of the requirements that would need to be fulfilled. The kind of thing that is found in the regulatory legislation in permissive regimes, what requirements are necessary to be fulfilled, what level of suffering, what level of capacity, how many psychiatrists or psychologists should be approached, how much time there should be allowed between the giving of the lethal prescription and the medicine, giving of the medicine, and so forth. And that would be a dangerous scenario, a scenario which would be completely against the interests of the vulnerable. So that would open, we submit, a can of worms that would be far worse than the legislation, which I think is accepted, although there's controverting evidence, which itself is difficult and not necessarily safe enough.
Why do you say it would open a can of worms? Surely the mere fact that all one could do is say that it has been misconstrued, it's gone too far, and one can't exclude that possibility, would be conducive to caution, not recklessness, and certainly not an attack on the vulnerable.
It would be clarification and more.
Just clarification, saying it seems to have been construed in some circles that this is its effect. That isn't what the judgment says, and it wasn't dealing with circumstances such as those raised by PSA, and those would have to be dealt with in accordance with the principles of our law if and when they do arise.
If Grochon is recognised as if it is recognised as I think it is, at least by the lawyers before this court, as being the authority on this issue.
Only one of the textbooks actually says that.
Then in the absence of that, which is understood as the prohibition of assisted suicide, and if that is undermined, then those who would wish to try and attempt assisted suicide would be given all the more encouragement to do so in circumstances where they were not afforded at least the protections that a permissive regime was afforded, and that is our point. Then, as concerns the second point which I wish to make is a point concerning judicial lawmaking. Justice Wallace indicated, I think in a question to Mr. Maneki, that an approach might be taken such as was taken by the court a quo in the Rodriguez decision, which was seems to have found approval in the minority decision, where the court a quo, and I haven't read the judgment, I rely on what Mr. Justice Wallace says about it, set out the requirements that need to be fulfilled for a permissible assisted suicide. The difficulty with that is that we submit is judicial lawmaking, because then the court itself is then entering into the territory of the legislature, and it is deciding and setting out the requirements that need to be fulfilled. We submit that the correct approach, if anything, would be the approach of the Supreme Court of Canada to declare an infringement and then to provide Parliament with the opportunity to correct and to provide the legislation. And that is a submission without conceding, of course, that there should be any such declaration in this case. The third point which I wish to make concerns just the raising of the right to freedom and security of person, and that as being a basis also upon which to claim the constitutional entitlement to assisted suicide. The response to that is that the right to freedom and security of person, as with the right to dignity, must be interpreted alongside the unqualified right to life, as well as in light of the fact that the goods which Section 12 are aimed at protecting, which is the human body, protect the very thing that assisted suicide aims at destroying. And we have referenced the Pretty decision in our heads of argument in this regard. What is claimed on the strength of the right is the diametric opposite of what the right protects. Then, just in relation to one final point which I think is necessary to make in relation to the distinction between the case before the court, or as it were here, and what happened in Carter, is that when the Canadian Supreme Court in Carter declared that there was an unjustifiable limitation in that case and directed Parliament to do something about it, it did so on the strength of the findings of the court a quo, which read as follows, and this is from the judgment of the Supreme Court in paragraph 115. Based on the evidence regarding the assessment process in comparable end-of-life medical decision-making in Canada, the trial judge concluded that vulnerability can be assessed on an individual basis using the procedures that physicians apply. So that was based on evidence. It was a finding made that this vulnerability can be assessed, but it was based on evidence. Then another evidential finding was that at paragraph 117, the trial judge, on the basis of her consideration of the various regimes and how they operated, found that it is possible to establish a regime that addresses the risks associated with physician-assisted death. So once again, on the basis of the evidence before it, the court decided, made the finding that in Canada a regime could be put in place that had sufficient safeguards. This court in this instance is just not in a position to make that determination, and in the absence of that, it cannot go through to make any order declaring a blanket ban unconstitutional.
Thank you, Mr. Conveyor. Judgment is reserved and the court adjourns.